something else.
Like the parliament.
No, Malas, I'm saying something else. The problem there is that the nature of this legislation is such that it is not just an ordinary legislation. It has ramifications on investment. It has ramifications on freedom of speech. It has ramifications on privacy. It has ramifications on not just WhatsApp, because today the target is WhatsApp, but it will impact every other intermediary in the system. And that's why 9 distinguished judges of this court said, in matters of this nature, we should await Parliament to pass a legislation. And I will invite your Lordship's attention.
That is a...
That's all that I'm saying. Yes. Therefore, mothers, what is going to happen between now and July, assuming that's the last date, it may pass in April, March itself. But assuming, mothers, it is between now and July, what's mothers? If at all, mothers. It took 6 years in the European Union to pass the bill. 6 years.
Maybe
one more thing.
Maybe I was wrong in choice of my word that Parliament will be benefited, but...
Lord, one more thing.
Yes.
Once Parliament passes a law, your Lordship does sit in judicial review, and your Lordship Lord, obviously can. But your Lordship's judicial review, your Lordship's judicial pronouncement being debated in Parliament for acceptance or rejection should always be avoided.
Yes.
Not that. Sometimes laws are passed overriding any decree order.
Well, if your Lordship renders a judgment earlier, what will happen? It will be debated.
It would be debated, but and the purpose is, the purpose possibly, I'm not talking about the litigants, here.
We are not on all this debate.
Discuss the bill and find out the inadequacies of the bill, criticize, etc.
We won't go into discussion over the bill.
No, but the issues are exactly the same.
And the irony is,
privacy, consent, they're all the same.
Lord, irony is, as I said yesterday, I'm supporting the users, namely Mr. Ivan and the side he represents. If the bill comes into effect, it is the intermediaries who will have to challenge it.
My Lord seems to be very sure about that.
Your geographical position is not correct.
No, that's correct.
Yeah, that's what I said.
You don't know. That's a very good speculation.
Yes.
But quite frankly, Millers, I have not contradicted him even once. I personally know, Millers, that in fact, when the bill comes, it will support our position. That's what I think. Maybe my learned friend
there's nothing to challenge that.
Yeah, we can't speculate.
Be that as it may. This is our submission, Millers.
May I just make a few points in the nature of recapitulation, just one or two.
I just want to add one thing before he starts.
You are
I'm for Metamor. I'm for the main holding company. I just want to mention that there is no Vishaka situation. There are regulations in place now. Already regulations are there.
We said it yesterday.
There is a mechanism. There is an officer whom you can complain to. He have not made a single complaint to anybody, and they're challenging everything in the air. So it's not as if the people are helpless. This is a complete 2011 regulation with a complaint mechanism, grievance redressal officer. So it's not like Vishaka where the law is crying, it's a complete vacuum, or people's human rights are being trampled over.
Only one more addition, before
Lordship, just as we don't discuss sub judice, once it is before the legislature, what will happen is your Lordship judgment is Article 141, binding. Some legislature comes. Now, they should not be that your Lordship holds A plus B is equal to C, and then the Parliament says A plus B is equal to D in advance. That may lead to a slightly awkward position, if I may use a term.
Constitutionally awkward. Another aspect.
Just say one thing. These are discussions or debates in relation where there is no specific complaints we are dealing with. As I said, there is a 2011 regulation. That regulation is holding the field. Maybe adequate, maybe inadequate is one thing. But that's not a ground, to strike it out and then do what? The second one is on the anvil. The second one is on the anvil. The first one is not challenged. The statutory regulations are of 2011. They are not under challenge. These are, these are kind of allegations. If this happens, that happens. There's nothing concrete really speaking.
Yes.
So that
One addition, one addition.
Nothing, specific. Unless there is something specific, if it has waited, for so much time, another 2 or 3 or 4 months can't really make a difference.
In fact,
and have this clash between the legislature, doing one way, court doing another way, just because 2, 3, 4 months are in the interregnum.
But in fact, the question that they framed, but in fact, the question that was framed by them
for your lordship's consideration was whether the state should act to bring in a legislation or rules. Now that's what's happened. That's in fact the question framed, which is at page 778 and 7789 of the convenience compilation. That is what they wanted. Now there is a law. Now how can they now go beyond that?